person who's facing both a civil claim for childhood sex abuse and a criminal prosecution for child sex abuse wants to have the criminal case go to trial first, or be resolved first. If it's not going to go to trial, if it's going to result in a plea bargain or some other outcome, the accused person wants to have the criminal case finished before having to defend the civil case. Here's the reason. In our society, we have a privilege against self-incrimination. No one who is suspected of a crime, under investigation for a crime, is required to make any statements that could incriminate themselves. But the way that is applied, the way that rule works out, is different in criminal cases than in civil cases. In criminal cases, in a criminal trial, the prosecutor is not permitted to say to the jury, "Ladies and gentlemen, the defendant has refused to testify," and he wouldn't talk to the police either when he learned what he was accused of. He must have something to hide. It's more likely because of that he committed this crime, and you should take that into account in deciding whether he did. That's a forbidden argument. In fact, in a criminal trial, the judge tells the jury that they are not to draw any inference from the defendant's silence. That rule doesn't apply in a civil trial. In a civil trial, the jury is permitted to draw an inference from the defendant's silence. The jury is permitted to infer that he has something to hide, and maybe he did it. Maybe that's what he's hiding. So before having to undergo a deposition in a civil case or go to trial in a civil case, the defendant wants to have his criminal case resolved, so he's free to speak about the allegations without worry that he's got a criminal trial coming up in which the things he said could be used to put him in prison.